Continue this discussion on whether the right to die with dignity of a terminal patient should be allowed by law. Now, let's take you back to last Thursday. Judge Hans Fabricius granted an order that Robin Stransom Ford had the right to administer a lethal agent himself or have a medical practitioner assist him without the threat of prosecution or disciplinary proceedings. Let's take a listen.
The applicant is entitled to be assisted by a qualified medical doctor who is willing to do so to end his life, either by the administration of a lethal agent or by providing the applicant with the necessary lethal agent to administer himself.
Now, what happened was, I'm sure you know, Stransom Ford died on the same day from natural causes and did not actually get the ruling. He didn't even get to hear the ruling. He died before it. However, this has now prompted the Department of Justice and Correctional Services to appeal the order. This for many reasons, which we are now going to be discovering from the Minister himself. Michael Masutha is from Correctional Services and Justice. Good to have you. Thank you very much, Minister, for being with us.
And it's good to see you again, Leanne, especially with your voice still on.
Don't joke with me. To let viewers into a little secret, every time I see the Minister, I don't have a voice. So I'm not sure what it is, but I have one today, which is good. Minister, let's talk about this ruling. In fact, you have given me a whole new angle now. I believe you have given the order to the justice or your lawyers to actually try and get the entire ruling set aside because the actual applicant died before the ruling was given to him.
Yes. It's tried law, or it's tried in law, so to speak, that courts do not concern themselves with either trivia or academic questions. Now, the issue that arises is if indeed the applicant died, even if minutes before the order was granted, what purpose does the order then serve other than purely in academic, being of academic significance?
Yeah.
Now, in those circumstances, the issue arises, and that is, do we really have an order in the first place? And if we don't, equally, you can't appeal against an academic decision. So the entire process becomes moot. And that is the argument that I have directed my legal advisors to raise with counsel representing us, to say that the judge needs to be confronted with this legal question, whether the fact that the death occurred shortly before the order was granted did not in fact render the entire process pointless. But otherwise, if he refuses to accept that argument, we could raise that in our appeal later, but also raise other points on appeal, such as the fact that, even subsequent to the order, it could not be effected because this person passed on anyway. But further on, you also have the difficulty that this judgment specifically states that it applies only in relation to this particular case. Now, This is novel to me. The rule of the principle of stare decisis, which is the Latin word meaning the decision shall stand, simply means that once a court has made a decision on a legal point, that decision becomes precedent automatically. Now, how a judge then decides to exclude this particular ruling on a point of law and only limit it to this specific case, he would have to give very good reasons why.
Yeah.
Because, in simple English, what's good for the goose is good for the gander. Once a judgment has been granted in respect of a particular set of facts, any other case with a similar facts in future would have to be judged in the same way. That's how the principle of precedent applies.
Let's look at the standpoint of the South African government. Why are we so against, as a constitution, why are we so against assisted suicide when there are a number of people out there who are fighting for this? What is it that's leading you to not want this to happen?
You see, doctors are there to save lives, to bring relief to those that are in pain or under siege of disease, not to end life. It is not part of the role of being a doctor. I heard arguments in the public discourses last week, some people saying that the oath that doctors take of Hippocrates is over 1,000 years, and it's become a cake. Our entire common law is over 2,000 years, and the principles still apply today as they applied 2,000 years ago, because life has not changed much. We may be living in modernity, but the principles of life still apply.
Yeah.
To assist somebody to kill themselves at common law, you become a party to the crime of murder, because you, through your own hand, have contributed to that. But the other difficulty with this decision is that what does it mean in relation to the rest of the law? Take, for example, the law of interstate succession, where there's a principle that if you kill somebody, then you cannot inherit from that person that you killed. If, say, for example, a doctor happens to be in line to inherit from this person, would this judgment effectively mean that this person can still inherit? Because there is a common law prohibition against that.
Yeah.
Even you yourself, if you commit suicide, usually the insurance doesn't pay out your life cover and that kind of thing, because even killing yourself, I would argue, is not lawful. It's different when you're killing somebody in self-defense, or you're killing somebody in defense of somebody else's life. It's a different thing.
Yeah. But if we look at this particular case, and it is the fact that the terminal patient has an acceptable cognitive capacity and has made the decision by himself, for his future. And he is the one that is saying, please, I don't want to suffer anymore. I would rather go in peace and rest. I want you to take my life. Even in a case like this, where it is the patient's decision, the patient is aware of what is happening and is making this decision for him or herself, would this still fall into this ambit of what you've described?
You see, the killing of somebody else has to generally be discouraged. And it can only be acceptable under very exceptional circumstances. For example, as I said earlier, in defense of somebody else's life or in defense of your own life. But to simply assist somebody because for some or other reason have chosen that they don't want to live anymore, it's difficult, because at what point do you then say it is morally acceptable to allow somebody to be assisted to kill themselves? I mean, you might want to kill yourself because you're heavily indebted and you can't do it yourself. You want somebody else to assist you. You are in a deep emotional pain, maybe not physical pain. I mean, where do you draw the line? I think that the difficulty is, firstly, where to draw the line. How do you avoid abuse? And how do you avoid opening up society to all sorts of dangers of people being manipulated to kill themselves and being assisted to do so? Perhaps
in a case where if you write it in your own will, if you write it before, take for instance someone like me, I'm of healthy mind, I'm not ill at all, but I would like the decision that if I am, and the doctors have said that there's no way I'm coming back, but I have already written it in my will that I would like to have assisted suicide, to eliminate any form of interference. Would that work? Could that work?
Doctors, in terms of their ethical as well as their professional responsibility, are there to save lives, are there to bring healing, are there to alleviate pain.
Not to take lives, as you said. Not to take lives.
It's not within their domain to do so.
Having said that, we are aware, and perhaps you may be aware as well, that at some local hospitals, there is some form of active euthanasia that is out there where basically they say it's in the best interest of the patient. Perhaps, upping their dose of pain medication just so that they are comfortable and they go easily. Even though it is not called euthanasia, but in a way is a form of euthanasia. What is your response to something like this?
I've just lost my mother 2 years ago. She succumbed to a collusion between hypertension and high blood pressure and what's the other disease? But she spent a week in hospital. I think the last day or two of her life must have been extremely agonizing. And the way her last hour or so was described, she must have gone through a lot of pain. Yeah. She was a nurse herself for 40 years, and I'm sure she herself had many ideas of how to end her life before the real pain struck. But she died through natural causes. I mean, we all go in different ways. Some go through excruciating pain before they die. Others die peacefully. It's well, short of a better way to put it, up to God to decide when and how we go.
All right. Minister, we leave it there for this morning. Thank you for coming in. Thank you so much for talking to us here on the program. It's a conversation that I know all of you are having right now. I can see from Twitter now it's exploded. The conversation has got even more intense, where people are just wanting to find out whether or not this is the way to go or not. But so many people bringing religion into the equation, and that's using the formation of this. Minister, thank you. Thank you for being with us here on the program.
Thank you for the opportunity.
That's our Justice and Correctional Services Minister, Michael Masutha. Let's take a break. We'll see.